of or were released on bail for certain offenses punishable as a felony at the time of the new offense.
Chair recognizes Mr. Little.
Thank you, Mr. Speaker. Members, it's my pleasure to present SJR87 to the body for its consideration this afternoon. The purpose of this SJR is to require courts to deny bail to two classes of defendants relative to 9 separate offenses. The 9 offenses that I previously referred to as the Abbott 9 offenses are murder, capital murder, aggravated assault causing serious bodily injury or using a firearm, knife, club, or explosive weapon, aggravated kidnapping, aggravated robbery, aggravated sexual assault, indecency with a child, trafficking of persons, or continuous trafficking of persons. The classes of defendants we seek to deny bail through SJR 87 are 1, those previously convicted of an Abbott 9 offense and for whom probable cause exists that they've committed another of the same class of offense, and 2, those already out on bail for an Abbott 9 offense and from whom probable cause exists that they committed another one. I had an epiphany last night that I'd like to share with you. My family was able to come down last night. I was sharing with my wife what I was doing today, and we had a short visit around SJR 87 during which she said, "Isn't that like the biggest no-brainer ever?" It is. For those of us who are stuck here in this endless loop of eat, sleep, floor, repeat, it becomes easy to forget that there's an entire state of 31,290,000 people out there counting on us to keep them safe from the most violent people that we have. I asked OCA to provide data on the total number of defendants over the last 2 years who were alleged to have committed an Abbott 9 offense while already out on bail for another one. The number they gave me was 2,650. Out of over 31 million Texans, we're talking about an effective class of people that amounts to 0.0084% of our population. That is a number that is so infinitesimally small that it will not matter to you unless you are Paul Castro and your son David is shot on the head on the freeway in Houston for no reason at all. It is a number that will not matter to you unless you are Alexis Nungaray and your daughter is gone forever. You may be wondering how this is going to affect you and your districts. In Dallas County, Byron Carrillo was granted bail for aggravated assault with a deadly weapon, only to later murder an entire family of 4 while he was on bail. In Travis County, Irvin Coronado Palacio was granted bail on a capital murder charge, which was reduced to an aggravated assault with a deadly weapon, only to later engage in human trafficking and sexually assault 2 children. In Harris County, this story has played it out time and time again. A recent example is the murder of Harris County Precinct 3 Deputy Constable Omar Urson while he was out picking up dinner for his family. Both defendants who are accused of that murder were already out on bond for previous murder charges at the time that that deputy was killed. Out of courtesy, I will decline to name the judges who released the alleged murderers on $75,000 bond for the previous murder charges. It was all preventable. It was all preventable. I think my colleagues on the Criminal Jurisprudence Committee will tell you that my concerns for the civil rights of all Texans are very sincere. In fact, there are probably times this session that the district attorneys had preferred I had not shown up to work that day. So let me take a moment to discuss what the law is and what the law isn't on this topic. The seminal case on this matter is the 1987 decision by the United States Supreme Court in United States versus Salerno. Let me tell you briefly what it says. 1, while the 8th Amendment to the Constitution prevents excessive bail, bail is not a right as a matter of law on every offense. The case provides that bail shall not be excessive in those cases where it is proper to grant bail, meaning that you and I have the ability to decide today in what cases we do and do not grant bail in this state. Salerno states that the right to bail is not absolute. The government can pursue its compelling interest of public safety by regulating pretrial release. You have the opportunity to bring balance to this issue today and protect your constituents at home who are living under threat of violence from offenders who should not be free to roam the streets. We know in our heart that this is right. we can fix this problem together.
Mr. Martinez, for what purpose?
Mr. Speaker, will the gentleman yield for some
Gentleman
questions?
yield for questions?
I will.
He yields for
And Mr.
questions.
Little, thank you very much for laying that the bill out. I just have a few questions for you about the number of people we're capturing here. How does SJR87 relate or compare to SJR5?
SJR5 applies to literally everyone. So if you think about everyone who's charged with one of the most serious offenses, in SJR5, we decided to allow the court or require the court to decide by a preponderance of the evidence if that person was a flight risk and deny bail, or by clear and convincing evidence if that person is an ongoing risk to public safety. And so this SJR is a little bit different. It requires denial of bail, meaning there's no discretion if there is a prior conviction of that defendant for one of these most heinous offenses, or they are already out on bail for one of these alleged offenses.
And then those offenses, would it be the same 9 offenses as described on SJR5?
I believe that's correct.
Okay. Have there been any efforts to narrow the list of covered offenses?
Yes. In fact, when we started out this session, the gentleman beside me, you can see up here, we've spent literally dozens of hours in meetings, not only with our compatriots on the other side of the aisle, but with the governor's office and senators, trying to confine the list to the most heinous offenses because we did not want to capture every felony. If you talk about every felony in the world, there's literally over 3,000 of them, I believe. And so the purpose is to confine this in a narrow way to the most violent people that are out there committing these crimes.
And I think one of the big questions that we had earlier was aggravated assault, and I have my notes here. And how has that been narrowed? And in regard to causing serious bodily injury, does it include a bar fight? I think there's a lot of questions on that, and I think the body wants to understand that a little better because I definitely did have a...
Thank you. It's a very important question. There are some 30,000 ag assault cases a year. And so if you took all of those and put it within the scope of this bill, you run the risk of jail overcrowding or not capturing the most serious ones. So what we did to compress that number of 30,000 to the smallest possible number is we only took, within the scope of these bills, aggravated assault causing serious bodily injury, which are the most serious kinds of ag assault cases that can be punished up to 99 years, or those involving the use of a firearm, knife, club, or other type of explosive weapon.
And you're talking about a firearm. So what if I'm carrying a pistol? I don't draw it, but I have it on me.
That would not qualify at all.
Right.
This is somebody is taking it out, pointing at someone, putting them in fear of loss of life or serious bodily injury.
So if one of my constituents is driving, a member of the family, and gets into a fight, has a pistol, he's not going to be held liable for that.
No, absolutely not. And self-defense or defense of others, certainly family members, that is not going to be within the scope of what we're doing here.
And then finally, one last question is in regard to trafficking. And are we talking about sex trafficking? What type of trafficking are we considering in this bill?
Yes, so among those offenses, we've got trafficking of persons. I think probably the representative here who knows the most about that is Representative Johnson. We're talking about 20A offenses, trafficking of persons, either human trafficking in the traditional smuggling people, or the, I guess, less traditionally understood version of that, which is, for example, running a prostitution ring, something along those lines. And then we also pick up continuous trafficking, which is multiple people, multiple offenses.
Thank you very much.
Thank you.
Mr. Romero, for what purpose?
Does the gentleman yield for questions?
Gentleman yields. For questions?
certainly do.
He yields.
Thank you, Representative Little. A couple of questions. Can you show where the SJR judges are allowed to weigh a person's current circumstances, like the ties to the community, work history, risk level, and decide whether release is appropriate?
Those will not be considered in this SJR.
Does the resolution require judges to order jail based only on the nature of the charge in the person's past, without considering whether detention is actually necessary in that specific case?
This SJR does not touch on previous charges, except in one circumstance. So We will be denying bail for people convicted who have an actual prior conviction of those charges, who are out on bail for one of the same charges on an earlier alleged offense.
So they could potentially be out on bail for one of those previous charges, but not ever being convicted, therefore never actually been found guilty. But because they were charged a second time, not the same crime, but one of the 9 could be held without bail.
You're correct about that, and the situation that I referred to earlier, similar situation with the assassination of the Harris County constable deputy. Those gentlemen who murdered him, or who are alleged to have murdered them, I would say, were already alleged to have committed murder in another case.
But there is potential that that person had never been found finally guilty based upon the charge, not final guilt, and still would be denied bail.
You're correct about that, Representative Romero. They would have to certainly be very unlucky to have been charged with murder twice.
The gentleman's time has expired. The following amendment, the clerk will read the amendment.
Amendment by Little.
Mr. Little.
Thank you, Mr. Speaker. Members, I hope that this amendment is loading for you. The purpose of this amendment is to designate this SJR as Jocelyn's Law, after Jocelyn Nungaray. I move adoption.
Question occurs on adoption of the amendment. Record vote. Clerk, ring the bell. Mr. Little voting aye. Mr. Smithy voting aye. Mr. Cook voting aye. Mr. Louderback voting aye. Ms. Luther voting aye. Mr. Berry voting aye. Have all members voted? Have all members voted? 140 ayes and 0 nays. The amendment is adopted. Anyone wishing to speak on, for, or against the bill? Mr. Moody in opposition.
Thank you, Mr. Speaker and members. I have heard the same story about Jocelyn Nungaray, and it is tragic, and it's something that should have never happened. I do want folks on this floor to know that the contents of this JR would have done nothing to preclude that tragedy from happening, because the facts of that are not the facts of what are contained in the JR. So I do want to set that aside. Her story is tragic, and it is one that, when I came here before you on a different constitutional amendment, it was more in line with the story of Jocelyn. So I do want to be clear that the facts of that case are not implicated by this joint resolution. So I think we do need to set that aside. SJR87 was filed just days ago at the end of session and rocketed over to the House. I think it is a terrible and a dangerous policy. And I strongly encourage everyone here to do one of 3 things: vote against it, hit the white light, or just sit back in your chair and don't vote at all. I want to emphasize how vastly different it is than SJR5, which so many of us voted for. That resolution, which many of us worked hundreds of hours to reach consensus on this session, had strong due process and put the burden on the state. It also considered the facts and circumstances of the new allegation, as we always do. This proposal is night and day to that. SJR87 is automatic. No real process, no due process, no consideration of the independent facts of the case. You have a prior conviction and someone accuses you of something new, straight to jail. Not only have you not been convicted of the new accusation, but nothing even has to be considered in terms of your dangerousness or your flight risk. We don't do that anywhere, ever, for any other kind of bail setting. We never have, and we shouldn't do it now. All that's required here is probable cause, which is an extremely low standard. In Texas, we have something that's called the one witness rule. If a single person's statement establishes the elements of the offense, that's enough. And at trial, that means that one witness has to be believed beyond a reasonable doubt after questioning and cross-examination. But at a bail setting, that person isn't questioned or examined. As long as the hearsay a judge gets isn't obviously false on its face, that equals probable cause. So under this resolution, it doesn't matter what the facts are. If you have a certain history, then someone accusing you gets you locked up awaiting trial automatically, maybe for years. Members, that's wrong and it's immoral, and we should reject it without a second thought. And I'll tell you this too about moving the goalposts on bail. We passed strong bail reform on the high end already, and now they suddenly want this. And there are multiple Senate bills on bail and these related issues that have already passed both chambers. 7, 8, 9, I can't keep count. And they will become law or be put before the voters of this state. Do you know how many criminal justice reforms the Senate has passed after receiving them from the House? 0. 0. Not one. Most, including those from Republican chairmen in this chamber that had a supermajority of votes here, haven't even been referred across the way. Haven't even been referred. So this just isn't about the bad policy contained in SJR87. This is about the dignity of this chamber. And I see Mr. Dutton standing at the back mic. Mr. Dutton, this is an expect us moment. And as I said before, vote no, hit the white light, or just don't vote at all. You have done an enormously challenging job when it came to balancing the rights and responsibilities and dealing with public safety on bail. This resolution goes impermissibly too far and does something we've never done in our law before, and we must reject it.
Mr. Dutton, for what purpose?
Will the gentleman yield for a question?
Gentleman yield for questions?
Yes.
He yields
Thank
for
you.
questions.
Now, one of the things that I have experienced is that when somehow or another they come to take away our freedoms, they first scare us to death. And then that makes it easy because then you sort of accept the fact that this is the consequence. But as you pointed out, the problem that they tried to scare us with, this bill wouldn't have fixed it.
No,
Is
sir.
that right?
That's correct.
Well, I guess I'm a little torn because I know there are a number of fixes to our judicial system that went out of this House to the Senate. Are you aware of that?
Yes, sir, I am.
Have any of them been considered at all by the Senate?
In terms of criminal justice reform measures?
Yes,
Last I checked, no.
not one.
No, sir.
Last time I checked, not one. And in fact, is it your understanding that many of them didn't even get referred to a committee?
Yes, sir. That's correct.
Well, if there's any time that we should say no to the Senate, simply because the process is broken between the House and the Senate, would you say it's this time?
Yes, sir. This is exactly that time. This is a policy that was pushed through in the waning days of session after we had had an enormous conversation on bail, one in which we all spent an enormous amount of time on, and I think we got right and we struck the balance. And when you take this JR in conjunction with JR5, so let's think about that. someone under JR5, if that becomes law, and a judge is granted bail to them, that means a judge has found that they're not a flight risk and they're not a future danger. And so just merely being accused of something again, it is going to be an automatic denial of bail. The only reason they would be out on bail is because we have said the judge must make a finding that they're not a flight risk and that they're not a danger.
And that's a part of the freedom that we all enjoy, isn't it?
Look, this comes down, and I know this gets a little bit philosophical here, but we have never done this. We have never turned this on its head to an automatic denial of bail. Nowhere in our jurisprudence have we done this on a mere accusation. The default setting, and I get it, some of these situations are tragic and they are difficult to deal with, but the default setting in our system, and we talk a lot about the Bill of Rights in this chamber, the default setting in this system is liberty.
Absolutely, absolutely. And one final concern, and that is that if we pass this measure, we all have to give up a part of our freedom. Because what this bill presupposes is that you don't have to be charged with a crime, not convicted of a crime in any way, but just be charged with a crime.
We are talking about a mere accusation upon probable cause,
Right.
which is the lowest standard possible for an automatic denial of bail,
Yes.
likely for multiple years. That is light years from anything we've ever considered in this body before.
And one of the comments from the author of the bill, he made an allegation about judges having released some of these people. But is it your understanding that the judges simply followed the law that existed at the time?
I'd have to look at every case specifically. I do know that there were a handful of cases under our prior law, and that's what SJR5 was aimed at addressing. Was
Right.
to get, well, not just SJR5, but go through the litany of things that we've talked about, putting magistration requirements, creating new guardrails for the granting of bail that we did on this floor just within the last couple of weeks. So this is not happening in
Gentleman's time
isolation.
has expired.
Thank you, Mr. Speaker.
Thank you.
Mr. Little to close.
Thank you, Mr. Speaker. Members, I think we are, I've had the great joy over the last 5 months of having an opportunity to work with Speaker Moody for dozens and dozens of hours on bail reform. Most things we have agreed upon. And I understand him and know him to be a moral and honorable man. Truly. The concern that I have that we pass this SJR is that if we do not pass it, we will not be able to properly constrain judges who would release certain very dangerous people onto the streets of our cities, our towns, our counties, in the state of Texas. That is the moral conundrum we are in. Are we willing to let the law remain unchanged and put more people at risk because they are at risk? One of the murders that was alleged that I mentioned earlier, one of those murderers who's been alleged in Harris County was released on $75,000 bond. They wrote a $7,500 check and they walked out of jail to commit another offense.
Mr. Speaker,
Mayor, for what purpose?
does the gentleman yield for questions?
Gentleman yield for questions?
certainly do.
He yields for questions.
Thank you, Representative Little. I appreciate your passion. I think everybody does. And no one wants to see someone that's, find themselves in a situation where this young lady lost her life or be a parent to that child. In that situation that you described, was that original offense that was committed, was that one of the Abbott 9 that you described?
A murder, yes.
So that person murdered someone and got out on 75?
Was alleged to have, I think is the proper way to say that.
So the person was out on bail. Okay, so to Speaker Moody's point, I just want to clarify a couple of things that were said. So there will be no more judicial discretion on these Abbott 9, no opportunity for electric monitoring, electronic monitoring, pardon me. So they are required to jail people without bond, correct?
On these 9 offenses for whom there is either a conviction or they are already on bail for one of those same offenses.
Okay. So could you see a scenario where your proposal could have someone held pre-trial for months or years based on probable cause alone, even if the judge was convinced that the person was not a threat?
No.
So because you don't see the judge ever seeing that person is not a threat after this proposal, if it were to pass?
Not after we have a known conviction or already having bailed the same person for the same alleged conduct in a separate violent incident.
So isn't the case that if SJR87 passes, this bill will be the first time in Texas history that our Constitution would require taking away someone's liberty without allowing a judge to consider the individual facts of the circumstances of this case?
No, the answer is in our Constitution we already have the ability. The judge already has the ability to deny bail on probable cause on capital murder. So we've confined or cabined that particular offense to permissive bail denial.
Okay. So they would not have to prove that detention is necessary under your law?
That what is necessary? I'm sorry.
The detention is necessary.
Correct.
Under 87, is there any requirement that a judge first consider alternatives to detention?
No.
After probable cause determination, what opportunity does 87 provide for defensive counsel to contest detention, cross-examine witnesses, or present mitigating evidence?
They will not be able to, and I want to circle back to the situation with this deputy constable who was assassinated in Houston, particularly. When those gentlemen came back and they were alleged to have committed a second murder, the defense decided to essentially waive bail, knowing that the community itself was incensed about their having been released the first time. So I think on the part of some defense counsel, they know intuitively what we're dealing with in this chamber this morning, that the community is rightly outraged at people who are released on bail for violent offenses and for whom new violent offenses are alleged.
I know that you point to that one case.
Sure.
How many other cases could there be that someone is now going to be denied bail? A U.S. citizen is going to be denied bail, but we use this one case, and now how many hundreds, maybe 10, maybe hundreds, maybe thousands of people will now be denied bail? And I think that goes back to Speaker Moody's point that for the first time, you have folks that are being denied bail without having to prove that they are a flight risk, that they are a threat to society. Let me ask you this question. So how does this proposal align with the procedures and safeguards in the Federal Bail Reform Act, which requires individualized risk findings and adversarial hearings before pretrial detention is authorized?
I'm glad you asked that question. So under the Bail Reform Act of 1984, the federal government similarly has the ability to deny bail. And so bail is not guaranteed under the Bail Reform Act of 1984, and the judge does have discretion to deny bail completely. It's why we use that, and in my amendment to SJR 5, we use that as a model for the evidentiary standard of denial of bail. The step that we're taking here is to take the discretion away from the judge to say, these are the most high probability violent offenders in our state, and OCA captured about 2,000 of them over the last 2 years that could be denied bail under a repeat offense.
Okay. If a court were to invalidate SJR 87 on constitutional grounds,
Yes, sir.
what safeguards are in place to redress the detention of individuals held under its authority during that period?
I'm not sure I fully understand your question. I believe, let me try to answer it. If this were found on a federal level through a district court lawsuit to be unconstitutional, I would expect to see an injunction. Normally when we have laws in this chamber that are made and someone believes they're unconstitutional and there's a federal lawsuit challenge, there's typically an injunction that goes along that. So I would expect there would be some type of injunctive relief staying the application of SJR 87.
Okay. Does your bill have any safeguards for if one of those Abbott 9 were committed when someone was 14, 15 years old, when they were a teenager?
It does not have a, it does not make a distinction as to the level of conviction. So let me just take your hypothetical. If we had a 14 or 15-year-old who committed murder and had a previous conviction and was
Let's
paroled,
say it was one of the lesser, and they got in a fight.
we want to choose one of those?
Yeah, let's use that, because the reason, and I'll extend on the question. There's a teenager,
Yes, sir.
grows up in a part of Texas that isn't the safest neighborhood. Maybe he was defending himself, but at that time that judge didn't have enough evidence to prove that it was self-defense and someone was harmed. 20 years later, maybe 30 years later, is now accused but not guilty. That young man or woman would be held without bail indefinitely. So I'm asking you, did you put any protections against a crime that might have been committed, one, by a teenager, and even further, 20 years later, any time period whatsoever?
There's no distinction as to the age of the offense in the resolution.
Could you understand how we have laws on the books today where someone maybe actually never committed a crime? Say, for example, the law of parties. You were a party simply because you were in the vehicle. You had no idea what was going on in the convenience store when somebody went to rob. That happened as a teenager. You're not responsible. And then later in life, 20 years later, do you not feel like that is an injustice, a violation of our constitutional rights, that someone is now being held without bail for something that they actually never committed the act?
It's an interesting conversation, and I'll say that the law of parties does not relieve them of criminal responsibility, nor is that a thing that we are able to say about that person. If under the law of parties they are convicted of, for example, aggravated robbery or felony murder as an example, we don't make a distinction as to whether they were the getaway driver or participated in the crime or pulled the trigger themselves. So I will just say that there is not a distinction there, and that once that conviction has occurred, everyone's on notice that if there's another commission of one of these most violent or heinous offenses, they will be denied bail.
Do you believe that person is guilty of murder if they had no idea, and even if the person that actually did commit or pulled the trigger said that person was not responsible?
I think there are endless permutations of that same fact pattern that I've seen, and there are various grades.
Gentleman's time has expired.
Thank you.
Members, strict enforcement has been requested on SJR 87. Members must vote from your desks, and you cannot vote for any other member. The question occurs on adoption of SJR 87. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? '93 ayes, 32 nays. SJR 87 passes to third reading.